All right, so you're Dalton Batiste. Answer out loud, please. And this is cause numbers 25 DCCR 1436, 1437. In each of those cases, Mr. Batiste is charged with manslaughter. And then in 24 DCCR 0407, charged with possession of marijuana. And what is the announcement?
We've sent objections to the court, Judge.
Go through that. Sorry, I didn't. All right, so Mr. Batiste, in each of those manslaughter cases, the range of punishment if you're found guilty by a jury, that's the state jail. Sorry, I had the wrong one pulled up. 4 seconds, correct?
Yes, Judge.
It's between 2 years and up to 20 years in prison in each of those cases. And then in that possession of marijuana case, if you're found guilty by a jury, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand? And I have here on the tablet some plea bargain rejections that you've signed with Mr. Kelly that shows that the district attorney's office has made offers if you wanted to enter plea of guilty for 10-year term in the manslaughter cases.
I don't think we sent a third one, Judge. We didn't.
With, I guess, something on that state jail that would run concurrently with that. So it would be 2 10-year sentences, but they would run at the same time. And then whatever you got on the state jail would also run concurrently or at the same time. You have every right to reject those offers and have all of your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plead guilty. And do you understand all of that? And do you want to reject those offers and have all of your cases set for trial? All right, we'll get them set on the trial docket, and Mr. Kelly and Mr. Gertz will get them in preparation for trial. You can go back with the bailiff. Thank you. Yep.
Those are actually, they're prior that it hits that for the first time. So
Did they?
they're in the indictment.
Dalton Batiste. Guess Tom's already gone.
They went back.
Would you grab Tom real quick? I'm trying to make sure. Would you send me back one of the rejections?
It's in the indictment. So
Did you go over with him, the enhancement at first? You've already you've gone over that and explained. I think since I didn't do it on the record, I want to make sure that's been done. Okay, perfect. Thank you. No, ma'am, I'm good. Mr. Rojas, you've got Jamon Adams. Good morning. Are you Jamon Adams?
Yes, ma'am.
And Mr. Adams, in cause number 26, DCCR 0744, you're charged with a 2nd-degree felony offense of aggravated assault with a deadly weapon. And that's from April 7th of 2026. And what that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes.
And I have here on the tablet a plea bargain rejection that you signed with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 5-year term in prison. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plead guilty. Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Adams, Mr. Rojas is your court-appointed attorney at this point, and he's one of the attorneys who handles a lot of cases for me as a court-appointed lawyer. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, Mr. Rojas, you're released. We'll appoint someone today. They should be out to see you very soon to begin preparation for trial.
Okay.
All right, you can go back with the bailiff.
Can I ask you a question?
You sure?
when it comes to the next lawyer, will I be able to tell you what really happened? Because the last time I heard.
So you just need to talk to your lawyer about that.
Okay,
That's who you need to tell everything. And then he'll talk to the district attorney and that's all kind of between you guys, not necessarily me, okay?
yes, ma'am.
All right, you can go back to the bailiff. Linton Alexander,
Clinton Alexander.
good morning. Are you Linton Alexander?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Alexander, in cause number 26 DCCR 0601, the state has elected to proceed on the lesser offense of a third-degree felony attempted burglary of a habitation from March 12th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Alexander is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of attempted burglary of a habitation, sentence you in accordance with your agreement to a term of 5 years in the institutional division.
Should be 4, Judge.
Judge, I think, actually, I know, it originally was 5. Maybe Mr. Ross accidentally wrote 5. We talked about it when I reduced it because the offer was 4. It should have been 4 the whole time. If I didn't catch it, that's on
Nope.
me.
It says 5.
It's 4,
But
yeah.
I'll
I'm
check.
sorry, Judge. It's supposed to be.
That's okay.
Cool.
Hold on, let me,
Yeah.
with everybody's permission, I
We
can change.
still catch it.
By this stage, the hearing wasn't about emotion. It was about constitutional rights, sentencing ranges, and informed decisions. Every defendant had the right to reject a plea, but each rejection carried significant legal risk.
All right, so I'm going to sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Rojas.
Okay.
All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
There you go. Are you Janaea Fine?
Yes, ma'am. Yes, Your Honor.
And will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Ms. Fine, in clause number 26 DCCR 0432, you're charged with a second-degree felony offense of assault on a peace officer from January 13th of 2026. And how do you plead to that charge?
I plead guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they charged you with?
Yes, Your Honor.
And then we have clause number 26 DCCR 0433. And in that case, you're charged with a third-degree felony offense of harassment of a public servant. And that's from January 13th of 2026. And how do you plead to that charge?
I plead guilty.
And are you also pleading guilty in that case freely and voluntarily?
Yes, Your Honor.
And because you did what they charged you with?
Yes, Your Honor.
In both of those cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, Your Honor.
And do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
And it looks like the agreement that you've reached in each of your cases is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, Your Honor.
Do you also understand if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number one in each case?
No objection.
It's admitted in each case. Is there any evidence that Ms. Fine is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we'll come back later for sentencing. Before we talk about the bond, there is only a fine in 0432 of $500. There's no fine in 0433. And so, Ms. Malfino, what's the state's position with regard to
No objection.
a bond? So, Ms. Fine, what I'm going to do in each of your cases, based on the nature of your plea agreements, is reduce your bond in each case to $1,000. I'm going to make those personal bonds, which means you don't even have to pay any money. You're just going to get released from jail today. But there's some very, very important things that have to happen between now and when you come back for sentencing, if you want me to go along with this deal. The first thing is that when you are released from custody, the very first thing you do is go to the probation department. You're going to get some papers today. It's going to tell you where to go. So you have to go straight there so they can start that process to get that report from you. Okay.
Okay. Yes, Your Honor.
If you don't do that, then obviously a warrant could go out for your arrest. I don't have to follow this agreement. Things could be a whole lot worse. So it's very important that you do that. Okay.
As long as the address on it, Your Honor, I'll go.
The address will be on it. You'll talk to a probation officer in the courtroom today before you leave, and she'll tell you everything you need to know about where to go. Okay.
Okay.
The next thing is that you cannot get in any trouble or arrested for anything between now and when you come back. If you get arrested for anything, you run the risk of me raising your bond, or you'd be back in here and I don't have to follow this agreement. You understand?
Yes, Your Honor.
All right. You can go back with the bailiff. We'll
Thank
see
you,
you at
Your Honor.
sentencing.
The courtroom treated every defendant differently based on the facts of each case. Some chose trial. Others accepted responsibility. But every decision carried lasting legal consequences.